The presidential candidate of the People's Democratic Party, the PDP, Atiku Abubakar, has joined the League of Political Parties who are seeking redress over the conduct and outcome of the presidential election. He has officially approached the tribunal to contest the declaration of Bola Tinubu of the APC as a president-elect. This comes hours after the Labour Party and its candidate, Mr. Peter Obi, had similarly filed a petition at the Election Petitions Tribunal in Abuja, challenging Tinubu's status as the winner of the February 25, 2023 presidential election. Let's get some thoughts on what this means and why the PDP is challenging what they are really praying for, praying against the declaration of Bola Tinubu, and what all the things that are included in that prayer. I'm being joined by one of the spokesperson of the PDP PCC. He joins us virtually, Mr. Daniel Bwala, and also our lawyer, members of the Lincoln team. Thank you so much, Daniel, for joining us tonight. What exactly are the prayers of your principal?
Well, thank you for having me. The prayers are not far from what the Electoral Act provides in Section 134 to the effect that anybody who is challenging the outcome of election must come under either of these four grounds. Number one is that the election of the person who was declared winner is invalid by reason of non-compliance to the provisions of the Electoral Act. Number two is that the person who was declared winner his election is invalid by reason of corrupt practices. The third one is that the person who was declared winner was not fully elected by the lawful votes of the majority of Nigerians. And of course, the third one is that the person was the fourth one, the person was declared winner is not qualified. Now, we have covered all of those grounds in our applications, and we have a case that we can make to the court. For example, if you look at non-compliance to the provisions of the Electoral Act. I mean, everybody in Nigeria knows what INEC told us when they set the ball rolling. They said this is the rule. The electronic upload has come to stay. It is part of the amendment of the Electoral Act. The result will be uploaded. And all of those grammars, when they gave that in their engagement with stakeholders, they were asked whether there is a conflict between the electronically uploaded result and the manually transmitted, which one takes precedence. They said definitely it will be the electronically uploaded. That is also supported by the budget of the federal government to deal with ICT. So there is a clear intent on the part of INEC to apply the provisions of the guidelines, which draws its support from the Electoral Act that the electronic upload and transmission of the result will be sacrosanct. Did they follow that provision? We hold the view that that election is invalid because there is a non-compliance, and there are so many other non-compliance around that. Number two, this is an election where you saw corruption and corrupt practices in terms of vote buying, covered by the media, covered by video, covered by audio, even the law enforcement. The third one is that the person who was declared winner was not declared by the lawful vote of the majority, but not by the vote of the lawful majority of the country. This is where they committed what I call 21st century criminal conduct, even though it is not in the criminal law, where they use the advent of the electronic transmission of result as a reason to perpetuate corrupt practices in terms of manipulation of result all across the country in one swoop, and take that hard copy to INEC so that INEC now use the results they were holding in their hands to declare. All you need to do is to look at their IRA. So now they have finished uploading the IRA. If you look at it, you see that the result that was announced totally inconsistent with what you see there in the IRA. So he was, by the time you do plus and minus and you take everything out, you discover that their victory cannot be sustained. Don't forget also the provision of Section 130 sub 2 of the Constitution, which also says that even when you think that the person has scored a lawful majority, there is still a test too. Has he scored a 25% in the FCT? INEC ought to have advised themselves, but they never did. And then the last one, which is very, very critical in my view, is the issue of qualification. And you can see that you probably in the course of this our campaign, we have appeared in your studio where I was having a back and forth with Festus Keyamo about the certificate of that candidate. So there are lots of controversies around the certificate. Some people have stretched it further to talk about conviction in America and whether that person can be. So all of these things are part of the many more reasons we have brought to the court. There is only one request we have, Mr. Sheon, and the request is for the courts in the land to abide by what they say from the beginning, that the courts is about time they depart from technicality and focus on substantial justice. Substantial justice is whether the thunder comes down or not. You must come down to the case of who scored the lawful majority vote. No procedural area of law should invalidate substantial determination of this matter. What is the premise of our prayer? Because if you look at Africa, you will see that democracy, there is an attempt supported by the global community to deepen democracy in Africa. It has happened in Malawi, it has happened in Kenya. These are places where before now you would have heard they say Supreme Court would never annul themselves. It's the tradition you see in Nigeria when people say Supreme Court has never annulled, therefore Supreme Court would not. Hold on, take your popcorn, take your drink, sit back and see. In the face of overwhelming evidence, the Supreme Court will hold your case and sustain it. This is the belief. Our prayer is that technicality should not be used. Substantial justice must be given to this case. And number three, the institution of state must not use their overbearing power and compromise the judges or compromise the processes. American Embassy have backed us on that. And in fact, the world community have also said that the local laws in Nigeria must be adhered to the adjudication of the matter.
So you were telling us the details of the petition against the declaration of Bola Tinubu of the APC as the president-elect. What are the other things that we need to know as far as the challenge that you and your party have thrown to the courts?
Well, you know that because the matter now is lis pendens, it has not gone into the court, I will be careful not to discuss the strength and weakness. I will just be telling you what we have brought to the court and probably tell you facts that are in public space. For example, the vice presidential candidate, who is now the vice president-elect, you know that it is of public record that when he accepted the nomination as the vice president, he has not turned over his nomination as a senator. It was the next day after he has accepted that he turned over. And you know, of course, what the Electoral Act says, that where there is a case of double nomination, that candidate stands disqualified. So if you look at that, and then you just oppose what the Supreme Court said in Doe Ediri's case and David Leon, they say whatever affects the vice president affects the presidential candidate, whatever affects the deputy governor affects the governor because they came on a joint ticket. So even on that qualification too, they will knock them off. And by the time you knock their qualification off, then the person who scored the highest, the next person who scores the highest vote now becomes the winner of that election. We know that our case is strong. That's what we have good cause of action. That's why we came to the court. Our prayer, like I said earlier, is for the court to do justice according to law. There is this thing called justice according to law. And let me tell you what I mean by that. You may have heard that the Supreme Court is a court of justice, but also the court of public policy. You see, when it comes to determining election petition, my view is that the court should wear the gown of law and justice and keep aside the issue of public policy. Because the part of public policy that invokes the jurisdiction of the court oftentimes is a departure from the law. That is where you find the masses saying we don't have confidence in the judiciary, because you may look at it from the face value that this is what the law says and it is pretty straightforward. But then the court will look at probably existential issue, other issues that they feel, okay, this will define the polity, this will maintain peace and all of that. So oftentimes when they operate, when they function as a court of public policy, more criticisms have come on them than when they operate as a code of law and substantial justice. And they have said it over and over and over and over and over again in plethora of cases that the court, the Supreme Court in particular, will look at substantial justice, determining who scored the majority of the lawful vote. In other words, going into the main substance of the matter as against using procedure and to knock off a petition or procedure in order to shy away from looking at it holistically. That's our prayer. And like I said also, secondly, is that there should be non-interference. Now, what we have also argued to foreign international community, especially the U.S. Embassy, when they reiterated that they are going to place sanction on interference with the election, and they mentioned visa, we said, no, you have to go beyond that to revoke green cards to anybody who interferes, revoke their U.S. citizenship, anybody who interferes, go beyond that to asset freezing. Wherever their asset is anywhere in the world, you reach out under the doctrine of extraterritoriality and freeze those assets. You can even invoke international criminal law on those individuals, because oftentimes when there is a compromise of the process, it results in the loss of lives. Look at the lesson, Mr. Sheun, and I think that Nigerian will learn. In Kenya, Kenyatta Uhuru, when the matter came up, there was nothing Kenyatta did not do in order to oppress and suppress the judicial system. As a matter of fact, report has it that about 1,600 people were killed by law enforcement because of the expression of dissent and all of that. But the Supreme Court of Kenya, even when they were told, what if you invalidate the election? There will be more crisis. If you validate the election, what about the cost of conducting another election? The Supreme Court holds the view, when it comes to determining justice, even if the entire country uses the entire assets of that country to determine the rights of people, is very important. And even if it takes for the country to turn upside down, the Supreme Court have often said that this is where we stand like a rock of Gibraltar and the heavens will not fall. This is what we need from the Court of Appeal and the Supreme Court in the case of this election tribunal.
I see that there's been a lot of overtures that your party and some leaders in your party are making to international interest over this election, especially as it has now gone into the corridor of the judiciary. Do you believe?
No.
Do you believe?
No.
Do you believe in our legal system to give justice in this matter?
So this is how the world is framed. You have the local government, you have the state government, you have the national government, you have the sub-region, and then you have the global community. They all exist intertwined. That's why anytime there is a violation of human rights in a country, then the cry is not limited to that country. You have to invoke the powers of international community. That's why you have the United Nations. You have so many other treaties. All of these things exist so we can bring a firm country that obeys not just international treaties and laws, but even the local laws. You can look at it all over the world. Even us in Africa, I remember in our military era, when our sub-region had one problem or the other, the president of Nigeria will play his part in ensuring that in that country the rules of engagement are followed. There is no overture. When you have a ruling government, right, the president of the ruling government said the decision of the election is sacrosanct. You see the court of law? Why wouldn't you need international intervention on that? Because you are preempting the judiciary by saying that. You are preempting the court. He is not supposed to say the election and the victory of Tinubu has come to stance because you are not the court of law. In the same way that, with the greatest respect to Mr. Dati, when he is talking about there is no need for going to the court, there should be restoring and all that. These are extra constitutional matters. The nation cannot succeed until we abide by local laws and international law. Now, why do you mention overture? Let me tell you why. Were it not for the intervention of the global community in both Malawi and Kenya, the Supreme Court of those countries would not have summoned the courage to deliver justice according to law, because the presidents of those countries intimidated the judges, intimidated the people. That is the practical situation we're in the country now. This was an election that was rigged like a daylight robbery. The president of the country did not deem it fit to speak to the INEC chairman that what about Section 65 you people talk about? The proviso said you have days within which you can review complaint. The man said, I will do it. He never did. But now in Adamawa, he said, we are reviewing it. Smack and outright hypocrisy on the part of the electoral body. So you have to have collaboration. And so why did we welcome the foreign observers? Why are Nigerians going to other countries of the world? The President Buhari, on many occasions, has sent Obasanjo.
Can you explain? Sorry. This may be a bit of a digress, but can you explain the uniqueness of Adamawa case? Is there anything that is out of the line being done in that process?
Yes, the election was conducted, and Governor Fintiri won the election. Then suddenly, they now say there is one election, one result that is to come in from the local government called Fufure. We are the candidate of that party who also was contracted by INEC to print sensitive INEC documents. Now, they said that there is one election result that is supposed to come from there. And it took the courage of one of the agents to stand before them and say, look, we will not allow this election to be manipulated. They stood their ground. That's why you see both Adamawa and Kano, the election results were announced at the end of the day. If this same thing was applied all over Nigeria, the result would have been different. APC did not win more than 5 states in Nigeria. I'm just being honest. Look at our last presidential election. In all the Northwest, from the result sheet that was given to us by INEC, the duplicate copy, in the entire Northwest, we sweep it with very large vote difference. But do you know what they did? They now went and upped their vote, and they were putting it small. You defeat here by 3,000, defeat here by 4,000. I have never seen manipulation or read anywhere in the world of a magnitude that we saw in this election. And the reason is because they faked the idea of beavers. There was nobody has talked so much about beavers than the INEC chairman and Festus. Festus Okorie was in fact seated there the day of the national coalition. Why was he mute in terms of interpreting Section 65? Why didn't he advise INEC chairman that this man has not scored 25% in FCT? Even if he thinks that it is right, why don't they advise the country and say, we hold the view and this is our interpretation?
Because, Mr. Bwala, Adamawa's election has not been concluded and results has not been announced and no winner has been declared just yet. Isn't that a bit different? That was why I was trying to get clarification, because a lot of people watching might get a bit confused from how you were able to put those two scenarios together, looking like they don't really align.
No. The point is clear. And it is not just the case in Adamawa. You look at all the states of the Federation. Okay, why did it take this long before, for example, Abia, for a result to be announced now? When was the election conducted? Was it not this same scenario that played out when the INEC chairman announced the day before he announced the victory? He said, we are going to take 3 states today because it was remaining 6 states. He said, we'll take 3 states today and take 3 the next day. But sensing that maybe there is an order or code that is likely to come, he decided to stay back till 3 a.m. calling the results. You know, all these places that you see where eventually results will be announced, why was the delay?
All right.
Is there new voting taking place?
Mr. Bwala, this is how I would like you to perhaps anchor on the program tonight. Now, APC has been declared as a winner of the presidential election of 2023. Your party and your candidate said he actually won the election. The Labour Party, just like you heard Mr. Dati here, and their principal said they won the election. So you are laying claims to winning the election. Labour Party are laying claims. Then in fact they said they have the figure to show for it that they won the election. So where do we go from here? Who really won the election?
No, the answer is simple. Nigerians need not to be confused. Most of the results of the Labour Party were the ones that gave them. They didn't have agents in most of the places. Who gave them the result in Lagos? That's number one. And number two, you see,
no, I don't understand. I don't understand. You say you gave them results. What?
The Lagos result that was announced by INEC. Labour Party were misled into believing that the result announced by INEC were the actual result they got, until we told them they actually got more than the result announced by INEC. And it is based on the result sheet that we have. We have agents all over the places.
Okay, so from your agent, you shared the result, the details of the result that you have with the Labour Party. That's what you meant.
When it was Lagos was announced and we saw their names and their numbers, we said that they got more than the numbers announced about to them in Lagos. And that is where this is a fair play game. But let me tell you why Labour keeps saying that they also won. You see, if you look at the exceptional provision of the Electoral Act, the only way somebody who didn't come second will sustain litigation is for you to claim you came first. Because other than that, you don't have a local standard in the election petition. Because if you look at all of those grounds, the person complaining against the declared winner is actually the person who emerged second. That's why even the judgment of the court say when you now void the vote, you will now announce the next person who scored the highest vote as the winner. Look at the case in Yari. So they are doing that, and I don't want to denigrate them because I support their right to exercise. But in terms of you are saying who is the winner, let me be honest with you, Shehu. if by the time this election is determined, based on the results, the duplicate copies that we have, we didn't just defeat APC with a small margin. We defeated APC with a margin about 4 million. And the truth will come home. These people did not win election in most of the places they speculated. Violence, voter suppression, intimidation, and awarding of contract to produce INEC documents to not just members of APC, but even people running for that office. And the president of the Federal Republic ought to have known. The law enforcement ought to tell him.
All right.
INEC chairman ought to know it.
So, yeah, we'll see how this all pans out, and we will be watching. Nigerians who voted will also be watching, and hopefully our nation will be better for it. Thank you so much indeed, Mr. Daniel Bwala, for your time tonight. I appreciate it.